Good morning, everybody. Thank you for joining. Hopefully you can hear me. Let's get this straight. I think Jeff can hear me.
Yes, sir.
Okay, good deal. Good morning and welcome to Clean Water Act webinar sponsored by ACEC Florida Land Development Committee. It's a first of many. We're trying to start something new with our new committee, and with us today is Jeff Littlejohn. Jeff is a PE and president of Littlejohn Mann and Associates. It's a Tallahassee-based government relations firm specialized in water, energy, and environmental policy. He also is the president of W Source Group, a Florida consulting firm dedicated to water resources, environmental regulations, and solutions for complex problems. He previously served as a deputy secretary for regulatory program for FDP from 2011 to 2014. Jeff also serves as ACEC Florida's environmental legislative consultant. And so he provides a lot of good input to us during the weeks, during the months, and as things are changing. So today he is going to give us an overview of what's going on with the Clean Water Act and how that's going to affect us in the land development arena and throughout Florida. So with nothing else, I think I'll turn it over to Jeff. Sam, if you can make that happen. And one last thing.
I think I'm live. Okay, go ahead,
Okay.
Mike.
I was going to say, Jeff, if you can just, if they're not hearing me, but if you can remind them that you'll take questions during the presentation, and also try to, they have to send their questions in through the text question link. We don't have any microphone capability since we have so many folks on the line, but if they'll send their questions in with the text, you'll do your best to answer them during the presentation and after.
Yeah, thank you for that reminder, Mike. Okay, well, I'm just going to get started. I think it's catching up. Good morning, everybody. My name is Jeff Littlejohn, and Mike, thank you very much for the introduction. We are already 7 minutes into a 30-minute scheduled call, so Sam has assured me that we can run long if folks are still hungry for more information and I'm not quite done. This is a little disorienting for me. Look at it, Mike.
Slides up,
is that
Jeff.
You trying to talk?
Yep, slides up.
Yep, I see it now. We're good to go. Technology has caught up. I was just saying that this is a little unusual, disorienting for me. I'm staring at a picture of myself talking to, looks like 113 people that I can't see. But please bear with us all. So we'll be talking about a segment of our section of the Clean Water Act that will be very near and dear to the development industry. We've all been dealing with this provision of the Act since its inception in the 70s, and we've been dealing with the Corps of Engineers in the administration of this section of the Act, and it's called Section 404. And a lot of people refer to it as 404, but a lot of other people refer to it as either the Federal Wetland Regulatory Program or the Dredge and Fill Program. So any of those terms are used to describe the administration of the Corps of Engineers regulatory authority over waters of the United States. What is significant, and the reason why we're talking about this today, is the state of Florida back in 2018 began a process to receive assumption authority, or another way of putting it is delegation of this authority from the Corps of Engineers to the state of Florida. And this would be really significant for Florida and for the development industry. It would mean that once effective, that you would get your federal wetland dredge and fill permit in some cases from the state of Florida instead of the Corps of Engineers. And for those of us that have practiced in this field for a while, we know that there's a lot of overlap between the state's environmental resource program, which includes wetland dredge and fill authority, and the federal wetland regulatory program. And that overlap can be frustrating, not just in the time and effort it takes to get both types of permits, but just in the fact that sometimes you can get kind of put through the ringer between those two agencies in a little ping pong death match. A little bit of background on 404, just to kind of get everybody in the same playing field. The authority to assume this provision or this regulatory program was actually put in place by Congress in 1977 when the Clean Water Act was last updated. At that time, only one state applied for the authority, and that was the state of Michigan. About 10 years later, the state of New Jersey applied for and received the program in the early 90s, and there have been no states that have received this authority since the early 90s, since the state of New Jersey. Florida actually had a couple of kind of half-hearted attempts, maybe 3 attempts to pursue the program. I was involved in one of the last half-hearted attempts. I'll say half-hearted because it was under my watch at DEP when I was at DEP in about 2012. And at that time, there was a lot of opposition from EPA. The state's wetland regulatory program had been around for, let me see, since 1995 by that time, so about 25 years. But we still had a lot of real and perceived barriers to assumption at that time, and EPA resisted heavily. One of the biggest issues at that time, and if you can think back to the regulatory landscape of Florida's state wetland regulations in 2011 and 2012, is we still had 5 different versions of ERP around the state, and that was really seen as a fatal flaw in the review and approval of the state's wetland program. EPA would have had to go through the 4 different water management districts with their own published rules, plus the special ERP rule for Northwest Florida. So one of the first things we did back in 2012 that really set us on the path to where we are today is get all of the state's wetland regulations under a single rule. And whether you call it statewide ERP or 62330 or SWRP, as it's sometimes called, that was really the first step or the first domino to fall. The next most important thing, or maybe even the most important thing, is with the election of President Trump and new leadership at EPA, there was a very strong push for cooperative federalism, which is a term used to describe EPA or the federal government trying to push authority, all the authority it can, down to states and really try to move back into a support role as much as it can. And EPA signaled that to DEP during the transition, and DEP in one other state, Arizona, responded back to EPA that we were ready, willing, and able to move forward. So the state took a package of information that had begun to be collected over the years and freshened it all up and began the informal kind of pre-application process with EPA. I'm going to mention some of the barriers because these barriers are all issues that have been dealt with in the last 2 years since this process has been moving forward. And in dealing with them, some compromises or negotiated outcomes have been reached. And whether you're a student of the new Rule 62331, the proposed rule that DEP promulgated to implement the 404 program, whether you're a student of that or not, there are some kind of interesting quirks that have been developed to overcome these barriers. And so I'm going to go through them one at a time. I'm just going to list them very quickly, and then we'll start to knock them off. So one of the first barriers, and those of you that have been in this industry for a long time will have heard, likely have heard that there is a definitional difference between the state and the federal wetland definition. And the state has a very prescriptive definition. It includes by species a couple of species that have been statutorily designated as a facultative species, and that's the slash pine and mulberry. And in the Corps of Engineers definition, those 2 species are treated in a different way. And the perceived prescriptiveness on the part of the state was identified or flagged as a problem by the federal government, by the Corps of Engineers and the Jacksonville office for decades as, once again, a fatal flaw. The fact that we define our wetlands differently than the feds means that we will never be able to agree on what is or is not a wetland. So right out of the gate, that was seen as one of the largest barriers to moving forward back in 2018. And what EPA did was they arbitrated, they acted as judge and jury during a series of meetings between Corps of Engineers, wetland regulatory staff in the Jacksonville office, one Corps of Engineers wetland expert from Atlanta, and then several state wetland experts from Florida. And the EPA reviewed a series of sites where the two different methodologies were applied. And what EPA concluded, and I happen to agree with this, is that the wetland delineations, the line between what is jurisdictional and what is not jurisdictional, was the same, regardless of the fact that the two definitions are different and the methodology is slightly different. So that determination really, once again, boosted everybody's enthusiasm for pursuing this authority, and DEP moved forward. The next issue that was raised is, how does the Corps of Engineers and the state of Florida differentiate between those waters that can be assumed by the state and those waters which must legally be retained by the Corps and retained in Corps jurisdiction? And the Clean Water Act actually spells out what waters are assumable and which waters are not. And it's relatively clear, but the devil is in the details of how that's implemented or interpreted. And there was a little bit of back and forth between the Corps Jacksonville office and DEP. Let me first start off by saying that what is abundantly clear in black and white is that if a water is a traditional navigable water, which means it is subject to the ebb and flow of tide, you can launch a boat from it, you can conduct interstate commerce or international commerce, then that's clearly a navigable water of the United States, and it is subject to jurisdiction under a different federal authority called the Rivers and Harbors Act. And the Corps of Engineers has exclusive authority to regulate waters, or regulate activities, that have an effect on navigable waters of the United States. And that authority, which is located in Section 10 of the Rivers and Harbors Act, is an authority that has not, the Congress has never provided any opportunity for the Corps to delegate that to states. And as a result, it has been maintained exclusively within the Corps. And that act significantly predates the Clean Water Act. The Rivers and Harbors Act was actually passed in 1899. And the Corps of Engineers has been dutifully implementing that program, since the early 1900s. By contrast, the Clean Water Act came around in the 70s, and so when Congress authorized the partial delegation of the 404 authority to states, it held back that authority that is exclusively within the Corps to regulate activities over navigable waters. So the next group of waters that could be assumed, but where there was a little bit of horse trading going on, is waters that is adjacent, or waters that are adjacent to those traditional navigable waters. Now, the term adjacency has been hotly contested over the years as the Corps implemented the 404 authority, and the subject of what is and is not an adjacent water, and therefore subject to the Corps' authority, has been brought up to the Supreme Court in a number of famous landmark cases that, again, practitioners would be familiar with this terminology, either Swank or Rapanos more recently. Those two cases both brought into question and attempted to resolve, the issue of what is subject to the jurisdiction of the Corps, what is a water of the United States. So that the fact that the term adjacent has not been completely settled, there was a little bit of controversy there, but we ultimately ended up settling on an administrative buffer approach, which conveniently and I think very helpfully has been applied in both the states of Michigan and New Jersey. So there were precedent for this. So rather than arguing over what is or is not an adjacent water to a traditional navigable water, and those can include, tributaries and non-navigable tributaries and wetlands primarily. Instead, the Corps simply said anything within 300 feet of a traditional navigable water where that is subject to the ebb and flow of tide or navigable tributaries to those waters that are subject to the ebb and flow of tide. If you're within 300 feet of those waters, they're going to be retained by the Corps. Anything beyond 300 feet is going to go to the state. So easy peasy. That got solved with an administrative buffer. I'm going to go ahead and bring a slide up. Sorry, I'm taking these out of order, but we're talking about jurisdiction right now, and I think it's will be more efficient just to go ahead and tackle this right now. So there's a couple of slides that I pulled from the DEP most recent workshop on 62330 and 62331, and I think these slides are pretty helpful because they illustrate how sites with split jurisdiction will be dealt with. And by jurisdiction, I don't mean whether it's a wetland or not. These on these graphics here, anything that's described as a wetland, we're assuming that both the state and the Corps would agree what is and is not a wetland and where the limits of the wetland are. But once that's done, when we're determining whether this activity on this particular hypothetical scenario would be administered or would be the application would be received and processed by the Corps of Engineers or processed by the state of Florida. So this is a pretty clean example. The water on the left there, the blue water, that's a retained water. It's a traditional navigable water. The wetland that is adjacent to it, it's directly connected to it, so it's clearly an adjacent regulated water of the United States. The project boundary is the dashed dot line, and the impact is areas inside there. There's a 300-foot administrative buffer line on there as well, and you can see that the project straddles the buffer. So this is an example where this project would be regulated by the Corps, and the reason for that is a portion of the project, since it straddles the line, by law must be retained by the Corps. There's a strong desire and frankly an impossibility, impracticability of having two different agencies issue permits for the same project, although we do that today with ERP. But for the assumption program, that's a no-no. Partial delegation is actually one of the prohibited provisions. So this is going to stay within the Corps. Similarly, for this scenario, Project 1, which is the one closest to the traditional navigable water, that's entirely within the jurisdiction of the Corps. That clearly stays within the Corps. Project 2 is a split jurisdiction project, and that would also be retained by the Corps because of the split. And then Project 3, even though it is affecting the same adjacent wetlands, it's beyond the 300-foot buffer, and as a result, that project would be administered. That application would be reviewed by the state and issued by the state if it meets the 404 requirements. And then here's one last example that the state provided. It's a linear project. Presumably there's a bridge crossing, and then it continues past the 300-foot buffer and crosses another wetland that is not an adjacent wetland. For this scenario, the adjacent wetland, because it's a water of the United States, that permit would be reviewed and approved by the Corps. The second wetland, if it is not a water of the United States, falls out of the Corps' jurisdiction. So the impacts to that wetland would not be reviewed and approved by the Corps, but it would still require an ERP because that would still be a water of the state. So a few different scenarios there. I'm happy to get into more details if people have some more questions, but for this call, I'd like to stay out of kind of a series of hypotheticals and that could be, in more or less detail and focus on the highlights. So split jurisdiction was resolved along the lines that I just attempted to describe. The next issue and identified problem is the conflict between the state law, which obligates DEP to issue by default a permit if they don't act on it within a certain time frame. And those time frames are provided in Chapter 120, which is the Florida administrative, is the Florida Administrative Procedures Act. And if you're familiar, you've ever heard of the term default permit, that obligation is provided in that chapter. I think it's interesting context to know that there has never been a state default of an ERP in Florida since its implementation, but nevertheless, that authority or that provision is on the books, and that was seen as a fatal conflict between the federal Clean Water Act, which does not contemplate nor does it authorize any default permits. So the way the state dealt with that is in the legislation that was passed in 2018 to support the state's pursuit of this authority. There was an exemption codified in 3734146, which is the implementing statute for this program. So there are a few provisions in 4146. I don't intend to talk about any more of them today. Generally, that statute was created to provide the state all of the authority that it believed it needed to pursue the program, and one of those was the carve out of that Chapter 120 default provision. The next issue, and one that we have, if you've practiced in this area for any length of time, you've come across this term. It's the alternatives analysis. Within the state regulations, we call it elimination and reduction of impacts. Within the federal regulations, it's called avoidance and minimizing impacts. But no matter what you call it, it's an alternatives analysis. And there are some relatively minor differences between the state and the Corps in alternatives analysis. Some of the big ones are the fact that the feds require an applicant to consider off-site alternatives. In other words, other types of properties that may be in the same market that could create the same opportunity to provide the project, but don't have the same amount of wetland impacts. And in the federal process, those off-site alternatives have to be considered. In the state process, they do not. There are a few other minor differences, and then there's also some differences in what type of mitigation is preferred. That concept is called the mitigation hierarchy. Those minor differences were resolved in a relatively simple way. The state simply said, we're not going to attempt to reconcile the differences. We're simply going to, in the case of an assumed water, where we are the lead regulator, we're going to adopt the federal alternatives analysis lock, stock, and barrel without altering a word. And they codified in Chapter 62331 by reference the federal 404B1 alternatives analysis process. So for a project where the state has the lead, they are going to use the federal process as if they were a Corps of Engineers employee. So what that may do, and we have, again, if you've practiced in this area a long time and done a lot of projects with Corps and ERPs at the same time, every once in a while you'll have a different alternatives analysis approved, and it may result in project modification, even if you've made it through one side or the other. That could still happen, and now that we have, you're dealing with the same staff, it hopefully will happen less. So the differences are still there. I don't want to let you think that the alternatives analysis issue or the conflict has been resolved, but the fact that the same staff are reviewing both applications should result in some benefit. There's just two more, I promise, and then we'll move on. The next one is permit duration. So the Clean Water Act specifically prohibits a delegated state program from issuing a permit longer than 5 years. But the Corps of Engineers can issue a longer duration permit, in fact, up to 20 years. So that difference, and this would primarily be significant for a very large development or for maybe a mining activity, having a federal 20-year permit was perceived as a real benefit. Not having to go back and get 3 more renewals was perceived as a huge issue. So the way that has been dealt with, because this is an actual federal law that prohibits it, is we are going to have a state program that tracks more or less the conceptual ERP process. So those of you that have done that before, you know that you can get a conceptual ERP for 20 years. And during that time, you can apply for, request, and receive multiple construction ERP permits for various phases of that development. And when you go back to the state and ask for that construction phase, the review process is relatively streamlined compared to the original application. And that streamlining is made possible because the overall project has already been reviewed. The overall impacts, maybe a master stormwater management plan, all that stuff is baked into your conceptual ERP. And when you're coming in for construction, you are simply asking the state to confirm that that construction phase application is consistent with your ERP, and the review is relatively limited. Similarly, if there are third-party challenges, those challenges have been limited in most cases to just the possible differences between that construction phase permit and the conceptual. So thinking about that as kind of your backdrop, what the state would be doing for a delegated 404 application is they would be asking the applicant for a very large development or maybe a large mining activity that's contemplated to go on for, more than 5 years, 10, 15, 20 years. They would be asked to provide the details on the complete plan, the complete project. So the full 20-year build out. And all of that information would be provided in that initial application. However, when the 404 permit is issued by the state, there would be a 5-year limit on construction authorization. So any construction that is planned to take place after the 5 years would have to be done in a permit renewal. And when the permit renewals are applied for, those renewals would be compared to that complete project information, those details that were provided in the initial application, and provided the renewal is consistent with those initial details, then that permit renewal would be, quote, expedited. And that expedited review, that's actually one of the other provisions that's codified in 3734146. It includes shortened timeframes. It also includes some limitations on third parties for challenging those renewals. So that was the solution that was developed that addressed the legal conflict between the 5-year and the 20-year, but still accomplished the overall objective in providing some assurance to those applicants of very large projects that they have some certainty that their 20-year project isn't going to come crashing to a halt on year 6. And then finally, and I'll save the biggest one for last because I do want to go through the Endangered Species Act as kind of a standalone issue, because this is one of the issues that is still not completely fully baked. We think we have a solution, but it is still subject to comment and review by both the public and a formal consultation process. So let me dive into the Endangered Species Act and why it's a problem, and what the state and the federal government sought to obtain in a solution, and then where we think we are, and then what's next. So the issue comes from the difference in consultation process in the Endangered Species Act itself. There are two different provisions in the Endangered Species Act where the potential effect on threatened species or their habitats or critical habitats are required to be reviewed by the agency, by federal wildlife agencies, typically the U.S. Fish and Wildlife Service, but also in some cases the National Marine Fisheries Service. So those two sections are Section 7 and Section 10. You've probably heard the term, Section 7 consultation. If you're in an unfortunate position of knowing about the Section 10 consultation process, or the Section 10, sometimes it's referred to as the incidental take permit process, you know that is a very challenging process to go through, time consuming, not a lot of certainty, not a lot of precedence for the Section 10 incidental take permits, and as a result, it's a pretty unworkable process. Those two authorities in the Endangered Species Act are both intended to provide for the opportunity for review of an activity on endangered species or their critical habitat, and And the purpose of the act is to prevent activities that would either have a major adverse effect, potential jeopardy of the species, so on and so forth. If you are a federal agency, you have the opportunity to request that the federal commenting agencies review the proposed activity and relatively expeditiously bring to bear their experts and provide a formal consultation to that project, and then provide a biological opinion and an incidental take statement if necessary. And all of that covers the federal agency under the Endangered Species Act. It also importantly provides a shield of immunity from Endangered Species Act criminal and civil penalties for a private party or a non-federal party that has received a federal permit after that consultation is concluded. If you do not go through a federal consultation process, then there is no immunity from the Endangered Species Act if an incidental take occurs. So that's a take of a species that you didn't contemplate, it wasn't planned, it was an accident, etc. But even accidents can be brought forward in a federal criminal or civil process, and an applicant or a landowner that is involved in such a take without incidental take coverage can find themselves in front of a federal judge. And so that's a problem. So the issue is, once the state assumes the program, does the state have the opportunity to utilize that Section 7 process, or would every applicant have to go through Section 10? If the answer is everything had to go through Section 10, then we wouldn't be talking about this today, because nobody wanted that. The state didn't want it, the feds didn't want it, applicants didn't want it. So the solutions were all about how to take advantage of the Section 7 process, but still leave the state in charge. So option number one that was ruled out was quote unquote federalizing DEP, maybe under a delegation agreement or a memorandum of agreement with the U.S. Fish and Wildlife Service, where the Fish and Wildlife Service would agree to use the Section 7 process for projects that may affect species, and then provide a biological opinion and incidental take statement. So that was deemed by EPA to be unauthorized or beyond the scope of what they could delegate. And so that was ruled out. That was probably the cleanest solution, but it was ruled out as beyond EPA's authority to delegate. So the second option that was considered was using EPA's built-in objection procedure. And what that means is, because this is a delegated program, at any time, or actually under certain circumstances laid out by EPA in our MOA, EPA can actually object to a state permit and pull it back and re-federalize a permit. So there was some abbreviated review of a procedure to pull projects from DEP using that objection procedure when there is an adverse or may affect determination by the U.S. Fish and Wildlife Service. That was also ruled out as pretty unworkable, but mostly from the applicant standpoint. There's a lot of frustration at the idea that, we're trying to do this to streamline, and yet we go through a state process. We think we're going to get a state assumed 404 out of the process, but then 6 months or a year into the review, we find out there's a may effect and the EPA pulls it, and then you start from scratch with the core. So that was seen as very unworkable. So finally, we arrived at where we are now, which is the Section 7 consultation has to be done by or initiated by a federal agency. It can only be initiated on an agency decision that is that's discretionary. And so what EPA argued is, and the state helped them argue this, is that the act of reviewing DEP's application is a discretionary federal decision that's subject to review and consultation under the Endangered Species Act. And so EPA brought in, with the state's support, brought in the process of how the state of Florida is going to review and consider potential impacts of species. And that description of that procedure was written down in something called a biological assessment. And that biological assessment was recently completed by the state and is currently under review by the U.S. Fish and Wildlife Service and the EPA. Comments are expected to come back soon. We hope that those comments are going to be all favorable. And then what will happen is that biological assessment would actually be subject to formal consultation under Section 7, and the U.S. Fish and Wildlife Service would issue a biological opinion and an incidental take statement for actions taken by DEP, decisions made by DEP that have followed the procedure described in the biological assessment. So I know we're already past time, so I'm going to try to compress what this process is going to look like and give you maybe a snapshot of how this would work. So for activities around the state that are subject to federal review, some of you are probably familiar with and have had to go through species keys. So there's a key for the manatee, there's a key for the wood stork, there's keys for indigo snakes. Those programmatic keys were developed by the Corps of Engineers and U.S. Fish and Wildlife Service to help expedite the preliminary assessment on what activities may or may not have an effect on species. And the intent of the keys is to help expeditiously determine what types of activities either have no effect or have what's called a MANLA determination, which is a may affect but not likely to adversely affect determination. And projects that key out to either no effect or MANLA right now can stay with the Corps without a formal consultation with the federal wildlife agencies, and those projects get expedited through. I believe, and I think DEP believes as well, that what we're going to see out of this biological assessment and what we're going to get approval by EPA and the Fish and Wildlife Service is to basically have DEP stand in the shoes of the Corps, and with training and with some oversight, the DEP is going to assist in the review of those determinations using those species keys that have already been developed, and the DEP is going to make the no effect or MANLA determinations. And for those projects where those determinations are reached, then DEP will move forward under abbreviated species review or no species review. The may affect determinations may get an informal review by the service, and if the service concurs that the project is a may affect, then EPA will object and pull that project back to the Corps to go through a full federal review and Section 7 consultation. If, however, there are project modifications that could be made to get that project pushed back down to a MANLA, in other words, some species impacts can be avoided by the applicant, then that informal consultation will allow the service to review those project modifications, those reasonable and prudent measures. And once the service concludes that those, after those modifications are made, the project now keys out as a MANLA or can have a MANLA determination, then the application gets pushed back to the state. So there would be a built-in incentive for the applicant to reduce or remove impacts to species to keep the project with the state. And the penalty box is you don't make the modifications and your project gets yanked out of the state review and it gets pushed to the Corps. So hopefully that was clear. I tried to jam a bunch of information in a short amount of time. I am going to talk about, well, let me check the questions real quick because I've gotten a handful of questions here. Yes, I will share whatever presentation materials I have. Okay, in the instance of where only the Corps had jurisdiction, a district permit would not be needed for surface water management. No. So like today, if you have a federal wetland, you need a Corps permit, and that federal wetland is also a state wetland, and so you will also need a state permit. So if the Corps retains jurisdiction, then you will have the status quo. It is the real benefit is when the Corps does not have jurisdiction, you'll have a single review by the Water Management District or DEP for both the state ERP and the 404 permit, and you'll get both permits by the same agency. Informal pre-application meeting with the Corps DEP first. Okay, let me address the implementation questions at the end. Somebody asked whether Section 6 authority was considered, and I do know that it was considered, but I think that that was seen as a much longer process. And this process that I just discussed was seen as potentially a transitory process or a transition process that could be replaced by a Section 6 delegation. And if you don't know where that is, that's a whole nother rabbit hole I don't want to pursue right now. But there is a provision in the Endangered Species Act where the state can actually get the entire consultation process delegated to it, and that authority is in Section 6. But it is not it's not a quick process. And then finally, will the DEP still be reviewing state review timelines when reviewing for the Corps as well? The answer is no. In 3734146, the Chapter 120 timelines were exempted from projects that are subject to or that are being reviewed under the state's assumed 404 authority. So shifting into the implementation world, what that would mean is for an activity that does have state and federal wetlands, the state review has got to proceed on these strict timelines and the federal review doesn't. Some might think, well, that's a hopeless exercise, but in fact, if you're familiar with activities that require both state ERP and proprietary authorizations, the proprietary process or the proprietary authorizations have no default provisions. So there are cases right now that involve overwater activities where the ERP is promptly reviewed under the time clock, but the authorization to use state-owned submerged lands is not subject to 120, and you end up kind of in a holding pattern with your ERP in hand, waiting for your sovereign lands authorization. So I suspect, in fact, I'm almost certain that that's going to be the reality for a project that has both ERP and 404, is you're going to get your ERP, more quickly than your 404, and you'll simply be sitting there with one of your two permits, waiting for the other. The benefit here is it's still the state agent, it's the same agency, and presumably that 404 process can happen more quickly. So I've talked a lot. I've tried to answer some of your questions. I'm already over time, but I do want to just briefly mention kind of where we are and what's next, and then I'll wind down and open the floor to more questions. So in order to apply for the program, there's a process laid out in the Clean Water Act. The state has to have the legal authority to take the program. It has to have a request by the governor. It has to have a legal opinion by the state attorney general, and then we have to have a complete package of the state authority that EPA would then review and hopefully conclude that the state authority is at least as stringent as the federal authority. So what we're lacking in Florida in the current ERP program are those handful of provisions that I mentioned earlier. The alternatives analysis, the permit duration, the Endangered Species Act review process, those things have now all been embodied in a standalone rule called 62.331, and it is the state assumption rule. And it is not effective until such time as EPA approves the rule, approves our program, but it is in fact a state authority. So once it's adopted, so it will have, it'll be one of the few cases I can think of where the state rule will be adopted, but its effectiveness date or its implementing date will be delayed until the program is formally approved by the EPA. But as an adopted rule, even if its effectiveness is delayed, it creates the right legal conditions for EPA to be able to review it for sufficiency. The good news, we think, is that since the state more or less just grabbed, without altering, all of the current Corps of Engineers review procedures and rules, it's pretty much a cut and paste in a lot of cases. The question of sufficiency is relatively limited. EPA is simply going to be reviewing the rules that the Corps already has, simply embodied in a new rule. So we think it's going to be relatively expedited, and certainly the feedback from EPA is all positive. But the state of Florida has to formally adopt 62.331. So where is that in the process? So we have gone through several workshops. The rules were first promulgated for public review back in 2018. Again, subject to lots of review and comment and workshops from the state. The state just did another series of workshops this year, and we're anticipating that those rules would become finalized any time now, basically. And somebody that's tracking that really closely may even know that there's a specific date. I apologize, I don't have a specific date, but I know it's happening soon. I know that the biological assessment was completed by the state and was delivered to EPA and U.S. Fish and Wildlife Service for review and comment. The program description and the memorandum of agreement are already done. So we're pretty much poised to submit our formal application package. And what I'm hearing from DEP is this would happen this summer. Once that happens, then EPA will publish that package in the Federal Register for formal public review and comment. And after that comment period, EPA will, during the comment period, the U.S. Fish and Wildlife Service formal consultation process under Section 7 would be concluded. And then with that formal biological opinion and incidental take statement, and after any changes that may need to be made based on comments from the public, then EPA would formally adopt. Then at that point, and that's a 120-day process, and at that point, we're off to the races. So this is the part where I'm going to be the most speculative. I'm hearing from EPA that initially, after approval, that the only DEP staff that would be performing these 404 reviews would be Tallahassee ERP staff, the group headed up by Heather Mason and Tim Rock. After some period of time, presumably to make sure that we've got the kinks worked out in any procedure, procedural kinks and interpretation kinks, and with some close review and support by EPA, there would be an effort to roll out a training program in 2021 to teach the DEP district ERP reviewers how to do this. And then possibly a year after, maybe longer, depending on how things are going, the same type of authority would be pushed out to the water management districts in updates to their operating agreements with DEP, and then finally the local programs. So that's where I'll stop, and I will be happy to take some more questions in the next 9 minutes. Okay, I got one more question in the chat that I'll take before we try to do the audio, Sam, if we want to try to do that. If there are no core jurisdictional wetlands, but you do have a federal species impact, then will DEP make a determination as to whether FWS is even involved? That's a great question. Whoever asked that question is a sophisticated professional practitioner for sure. That scenario is kind of a tough scenario now, and there are cases I've heard of where an applicant may even attempt to or intentionally trigger a federal review by clipping a water of the United States just to get that Section 7 consultation. I hope, and I'm not certain about this, but I hope that this procedure that DEP and U.S. Fish and Wildlife Service and EPA have all agreed to would allow DEP to make to do a review of the potential federal species impacts, even on a non-jurisdictional wetland. They would certainly have to do it if it's a jurisdictional wetland, but it's outside of the 300-foot buffer. But in the case of a state-only wetland, it's my hope that the state could conclude that a federal listed species effect in that state-only wetland, if it keys out as a MANLA, that determination could be confirmed by the service pursuant to this procedure. And as a result, you might be able to get incidental take coverage, even though you've never gone into even though you didn't get a 404 permit. That's my hope. I've not heard whether that's going to be possible, but I think that'd be a great outcome. 7 more minutes. Who else has questions?
Jeff, thank you very much. We have 2 more questions. The first one is, will the Southwest Florida Water Management District be able to confirm delegation at a pre-application meeting to be sure which permit is required?
Not initially. Initially, any determinations on assumable waters or jurisdictional calls under the 404 program would be made exclusively by DEP, and right out of the gate, that would only be done by Tallahassee staff.
Great, thank you. And it looks like our last question in the queue. Do you expect the ACEC-FL to develop more keys for additional species for use in this delegation?
I sure hope so. That's another great question. So as you can imagine, the more programmatic consultation processes that can be made where species effects can be determined through a prescriptive, procedure, the better, because those are opportunities to keep a project with the state. So there will still be a tremendous appetite on the part of DEP for sure. I hope on the part of the U.S. Fish and Wildlife Service and the Corps, although I'm less certain about that, to continue to find more places where keys can be used. So yes, the short version is yes.
And that concludes our questions.
Wonderful. I was either very thorough or I confused everybody.
Great. Well, thank you very much for joining us today. We hope everyone has a great day, and we look forward to having another webinar in the future with you guys.
Yeah, and I jumped back on, Sam, so I wanted to thank everybody for putting up with the new way to do business a little bit, and also thank Jeff very much for his time and all the effort going into this. Mark and Greg, who are on the line also, thank you for all your support, and Samantha especially. This is, I think, the first and largest of the GoToWebinar, so it's a little bit of learning for all of us. So thanks for everything you did, Sam. And thanks everybody. If you enjoyed this, let Sam know, and we'll try to work on some more in the coming future.
Thank you, Mike. Thanks, everybody.
Okay. Thanks, everybody. Have a great day. Great weekend.